Hello all, welcome you to the course on corporate laws and governance. In this video, we are going to look at the doctrine of constructive notice, doctrine of ultra vires and the doctrine of Indo management. First, let us look at the doctrine of constructive notice. Constructive notice is different from a normal notice. Normal notice would be printed, it would be sent to the person in real. But in the case of constructive notice means it is an implied notice, and with respect to the Companies Act 2013, what it means is any person who is going to deal with a registered company is supposed to know the contents of the Memorandum of Association and the Article of Association. Section 399 of the Companies Act deals with this doctrine of constructive notice. The company is supposed to give the Memorandum of Association, a copy of the Memorandum of Association and the copy of the Article of Association to whomsoever who asks for this particular documents within 7 days from the date of such request, either for free or by charging a very nominal fee. Section 17 of the Companies Act, read with Rule 34 of the Company Incorporation Rules 2014, insists this. In case anyone from the company gives any false information in the Article of Association or the Memorandum of Association, then they are liable for any of such false information. The person who is responsible for giving the false information would be penalized under Section 448 of the Act. So, if we look at this doctrine of constructive notice, this doctrine of constructive notice actually protects the company from the outsiders, because it insists that the outsiders should have the knowledge about the contents of the Memorandum of Association and the Article of Association. They cannot blame the company because of their lack of knowledge about the Article of Association and the Memorandum of Association of the company. This we can understand by looking at few of the cases. First, let us look at the case between the Kotla Venkatasamy versus Chinta Ramamurthy. If we look at this particular case, the Article of Association of the company clearly states that whenever the company enters into any kind of mortgage agreement, then that mortgage agreement should be signed by two directors, in the sense that one managing director, one whole-time director and the company secretary of the company. These three signatures should be there in the mortgage agreement, then only that mortgage agreement will become valid. But in this particular case, the plaintiff, what happened, the plaintiff got into a mortgage agreement with the company, and in that agreement, the agreement only had the signature of the whole-time director and the company secretary. It did not have the managing director's signature. So, when the plaintiff went to the court ruled out that in favor of the defendant, in the sense in favor of the company, stating that the plaintiff must have read the Article of Association, which clearly says that three signatures should be there in the mortgage agreement. Since it does not have the three signature in the agreement, then what happens? This agreement becomes invalid and the company is not liable, cannot be, it will not bind the company to this particular mortgage agreement. So, in fact, in this case we can understand that this doctrine of constructive notice protects the company. Let us look at the case between Dehradun Mussoorie Electric Tramway Company and Jagmandar Das. If we look at this, it is slightly different from the earlier case. The article of association of the company has mentioned that whenever the company goes for any kind of loan, the particular loan transaction should be approved by the director of the company. Then only anyone in the company can go ahead with the loan. But the managing agent of the company went for a bank OD, and this bank OD without the approval of the director, and the company went for a case against the managing agent, stating that the managing agent did not get the approval from the director before going for the bank OD, which has already clearly specified in the article of association. But if we look at it here, the judgment was not in favor of the company, but it was in favor of the managing agent, because the judge felt that this bank OD will not come under the provision of long-term loan. It is a temporary loan which is short-term in nature. So, we cannot equate to the provision of long-term loan where the director's approval is needed. So, here the judgment was in favor of the managing agent and it was not in favor of the company. Now, let us look at the case between Rama Corporation versus Proved Tin and General Investment. As per the article of association of the company, it is clearly mentioned that the company may delegate the authority to one of the directors to enter into any kind of loan agreement with the outsider. This is what has been given in the article of association. In fact, in this case, Rama Corporation went with an agreement, loan agreement with Proved Tin and General Investment, thinking with one of the directors of the company, assuming that the director had been delegated the power to enter into such a transaction. But what happened, the company did not want to go ahead with the loan agreement, stating that they have never given the power to the director to enter into the transaction on behalf of the company with Rama Corporation. If we look at this here, the judgment was in favor of the company, Proved Tin and General Investment, and it was not in favor of Rama Corporation, because the judge felt that Rama Corporation should have read the article of association, which clearly states that the company may delegate the power to one of the directors, and the Rama Corporation should have checked with the company whether the person with whom Rama Corporation had transacted with had been given the power to enter into the contract, which he failed to check. So, here again in this particular case, the interest of the company was protected and the doctrine of constructive notice was in play, that we can see that. Next, we will move on to the doctrine of ultra vires. If we look at the term ultra vires, what it means is beyond one's power. Here this is to do with the memorandum of association, and the whenever the company enters into any kind of transaction which is beyond the objective of the company, which is beyond the powers of the company, then any such transaction or any such contract will become void and it will become inoperative. Section 245 subsection 1A of the Companies Act deals with this concept of doctrine of ultra vires. And in a way it is good for the members of the company. This doctrine of ultra vires protects the interest of the members of the company, because whenever the members feel that the company is acting beyond its power, they can always go to court and they can stop such transaction. So here it helps the members in stopping the company to enter into any kind of trade which is not sanctioned by the memorandum, or it stops it helps the members to stop the company from employing its fund, which they should not, on those activities which are beyond the scope of the memorandum of association. So we can say this doctrine of ultra vires protects the members from those activities of the company which are beyond its scope and power. Sometimes what happens, the company has entered into a contract, the contract would be absolutely legal. Though it is legal, it doesn't make those activities or transaction or the contract valid, because once even the transactions are legal, once it is going to be beyond the scope and the power of the company, then it becomes invalid. And we have already seen this particular point when we learnt about the difference between the memorandum of association and the article of association. We do not have that retrospective effect in the case of a memorandum of association. The company gets into an act which is beyond its power. After doing the act, they cannot ratify it. Ratify means getting it approved by the shareholders. That can never ever be done. This has happened in the case of Ashbury Railway Carriage and Iron Company Limited versus Ritchie. This case also we have already seen. The company went with a contract with Ritchie for laying the railway tracks between two cities in Belgium. Actually, that particular act was beyond the scope of the company's objective as such, and actually after entering into the contract, this particular contract was ratified by the shareholders. Though it was ratified, that is approved by the shareholders in the general meeting, but the judgment clearly told that since it was beyond the scope of the objective clause of the memorandum of association, the contract between Ashbury Railway Carriage and Iron Company with Ritchie becomes invalid. So we do not have this retrospective effect in the case of memorandum of association. There are some exceptions. Let us see those exceptions. One exception that we have is there are some activities which are ultra vires the articles, but it is very much intra vires the memorandum. If that is the case, this can be made intra vires the articles, because the activity has been performed that had been beyond the scope of the article of association, but still the activity can be made valid. That is, that retrospective effect comes into this comes into the picture, where the company can get that particular activity which is ultra vires the article approved by the shareholders in the general meeting, which we call it as special resolution. That is 75% or more of the votes of the shareholders should be in favor of the activity or the change which the company talks about. And another exception is if a particular activity is going to be ultra vires the director, that is beyond the scope or power of the director, but it is intra vires the memorandum of association of the company, still again this ultra vires the director can be made as the intra vires the director by getting it ratified by the members by passing a special resolution in a general meeting. So this kind of retrospective effect can be done only when it is going to be ultra vires the article, when it is going to be ultra vires the director, but this kind of retrospective effects cannot be brought when it is going to be ultra vires the memorandum of association. Now let us look at few of the case laws with respect to the doctrine of ultra vires. The first case that we are going to look at is Jahangir R. Modi versus Shamji Ladha. In this particular case, what happens? The memorandum of association clearly says that the directors of the company cannot buy or sell the shares of the company in which they are acting as the director. But the defendant had sold the shares of the company in which he was the director, and so the judgment was against the defendant who had sold the shares of the company in which he was acting as the director, because that particular activity was considered as ultra vires. The famous case of Ashbury Railway Carriage and Iron Company Limited versus Ritchie, which we have already seen, anyways I will repeat. If you see here, Ashbury Railway Carriage and Iron Company's objective clause of Memorandum of Association clearly states that the company can make, they can lend the wagons, they can sell the railway wagons, and they can get into any kind of mechanical engineering, general contracts relating to mechanical engineering. They can involve themselves in the activities of buying and selling iron ore, timber, etc. But Ashbury Railway Company went into a contract with Ritchie for laying the railway tracks between two cities in Belgium, and they requested Ritchie to lay the railway tracks on behalf of Ashbury Railway Carriage and Iron Company. And the same contract was ratified in the general meeting by the shareholders. But the company did not perform, in the sense perform the contract. So Ritchie went to the court. The court clearly told that the contract between the company and Ritchie is invalid, it is inoperative, it is void ab initio. From the very beginning it is invalid, for the reason that this particular transaction contract is beyond the scope of the objective clause of the Memorandum of Association of the company. So this is considered to be the case of ultra vires. So the contract is invalid. If we look at the case of Lakshmanaswamy Mudaliar versus Life Insurance Corporation of India, Life Insurance Corporation of India was actually in the process of acquiring the insurance company that was owned by Lakshmanaswamy Mudaliar. So here what happened, in the process LIC found out that Lakshmanaswamy Mudaliar had been diverting the major portion of his profit from the life insurance business to the charitable organizations. Life Insurance Corporation of India felt that it was ultra vires, the company, the memorandum, the reason being the objective clause never mentioned that the company can use its profit to the charitable organization, so which was beyond the scope of the Memorandum of Association. Even the court felt the same, and they gave the judgment that whatever charitable donation that had been given by Lakshmanaswamy Mudaliar from his life insurance business was ultra vires. If we look at the case of Evans versus Brunner Mont and Company, Brunner Mont and Company actually was into the chemical manufacturing business. The Brunner Mont Company's objective clause of the Memorandum of Association clearly states that the company can involve themselves into any kind of chemical manufacturing business, and they can do any ancillary activities which will support the chemical manufacturing business. This is what the objective clause of the Memorandum of Association of Brunner Mont Company states. What the company did was, the company gave a substantial portion of its profit as a research grant to various universities. So Evans went to the court stating that distributing the portion of the profit as a research grant to various universities in UK is considered to be ultra vires the memorandum of association. So, but the judge, what the company told was, the company defended that whatever portion of profit that the company has given as a research grant to various universities, it is going to help the main objective of the company, which is getting into or promoting the chemical manufacturing business, because all these research grants are given for doing more and better research in chemical manufacturing, and this will help the company in knowing about the innovative methods, and it will also provide skilled labor force to the company. So, actually here the judgment was in favor of the company, because the judge felt that whatever grant that the company has given, it supports the main objective of the company, and all the ancillary activities which the company performs that supports the main objective is not considered ultra vires, it is all considered intra vires only. So, actually the judgment was in favor of the company. So, there is a provision in section 245 subsection 1A of the Companies Act. If any of the, as I have already told you, any of the members or the depositors, if they feel that the company is getting into any kind of activity which is beyond their scope, they can always go to the tribunal. The National Company Law Tribunal can be contacted, they can file an application, and they can stop the company from getting into any such activities which are beyond its scope. Next, we will move on to the last concept, which is the doctrine of indoor management. We know that doctrine of constructive notice is to do with protecting the company from the outsiders. This doctrine of indoor management protects the outsiders from the company's irregularities. So, if you look at it, the company may not be carrying out its activities correctly as they have told in the article of association. There could be some internal irregularities in the company. The outsiders may not know about such irregularities. So, the outsiders cannot be made a scapegoat for the irregularities that happens within the company. In such a case, the company would be made liable. So, this doctrine of indoor management protects the interest of the outsiders from the internal irregularities that may happen within the company, and the outsiders may not have knowledge about such irregularities, and they would be doing the transaction in good faith. Fine. So, this doctrine of indoor management is otherwise called as rule of Turkwan, because this was the first case where this doctrine of indoor management was talked about. So, if we look at the case of Royal British Bank versus Turkwan, here what happened, the Royal British Bank, they had issued the bonds. They have sold bonds to Turkwan, but they were telling that this particular transaction, the contract is invalid, because as per the article of association of the company must have got this approved. This issue of bonds must have been approved in the general meeting by the shareholders, but the company did not follow this protocol of getting the approval from the shareholders without passing the resolution. They had gone for issuing the bonds. So, this is the problem with the company, not with the person who has actually bought the bond. The company must have conducted the general meeting. They must have passed the resolution, post which they should have issued the bond. So, it is not the fault of the outsiders, because the outsiders always feel that the company must have followed the protocol and the rules as specified in the article of association. So, this was in favor of Turkwan, stating that the outsider cannot be made responsible for the irregularities that happens within the company. So, if we look at it, this section 128 of the Indian Companies Act talks about this doctrine of indoor management. It actually protects, as I have already told, it protects the outsiders against the actions of the company when they do not follow the rules which they are supposed to follow that had been specified in the Article of Association. Then if we let's look at some of the cases that we have with respect to this doctrine of indoor management. In the case of the Lakshmi Ratan Cotton Mills versus JK Jute Mitts Company Limited, it's very similar to the earlier case of Royal British Bank versus Turcot. Here what happened, the plaintiff got the bonds from the defendant, but the defendant told that the transaction is not valid because they didn't pass the resolution in the general meeting before issuing the bond, so the transaction becomes invalid. The judgment was in favor of the plaintiff because the company, it is the duty of the company to have followed the protocols which they are supposed to follow before they enter into any contract with the outsider. So, this particular case is very similar to that of the earlier case. Let us look at the case between Mahoney versus East Holyford Mining Company. In this particular case, Mahoney has entered into a contract with East Holyford Mining Company, but the company told that the contract between the two is invalid for the reason the contract had been signed by the directors, two directors. So, one of the directors' appointment was not done as per the rules, as a result of which the particular director's signature becomes invalid. This leads to leads to making the contract between Mahoney and East Holyford Mining Company's contract as invalid. Here, so Mahoney went to the court, but the judgment was in favor of Mahoney for the reason it is the duty of East Holyford Mining Company to have appointed the director as per the rules. So, if a particular director gets disqualified because of not following the rules, so they cannot put Mahoney in trouble for that. So, it is the responsibility of the company to have appointed the director as per the rules. So, the judgment told that the contract between Mahoney and the company will remain valid, though it has the signature of one of the directors who gets disqualified because of not following the rules, because Mahoney thinks that because it is the responsibility of the company to have followed the protocol. Next, let's look at some of the exceptions that we have with respect to this doctrine of indoor management. One is the knowledge of irregularity. If the outsider knows that there is a problem in the internal management of the company, when they have knowledge about it, then they cannot claim the benefits from the doctrine of indoor management. This we can understand by looking at the case between Howard and versus Patent Ivory. If we look at this particular case, both Howard and Patent Ivory both are the directors in a particular company. The company's article of association clearly says that in case any one of the directors is going to borrow money on behalf of the company, they are allowed to borrow only up to £1,000. If they are going to borrow beyond that, then it should be approved in the general meeting. Howard knows about it, but Howard has lent money to Patent Ivory to the tune of £3,000, and though he knew that this must have been approved in the general meeting, still he went for giving the money. So, here the contract between Howard and Patent Ivory becomes invalid for the reason Howard had known about the rule, and despite that he went for lending the money to Patent Ivory for the company. So, the contract becomes invalid. Howard cannot use the doctrine of indoor management principle here. Next, what we have is the ultra vires acts, like any activity which is ultra vires, the memorandum of association, then that becomes invalid. Once any activity, so here you cannot bring in the concept of doctrine of indoor management. Whatever activity which the company carries out, which is beyond its scope, then it becomes invalid. No one can bind the company to perform the particular act. This we have already seen the case of Ashbury Railway Carriage and Iron Company versus Ritchie, the laying of railway tracks between two cities in Belgium. The contract that was given to Ritchie was invalid because this particular activity was beyond the object class scope of the object class of Memorandum of Association of Ashbury Railway Carriage and Iron Company. Next, what we have is the forgery. If a particular person in the company gets into a contract through forgery, then the doctrine of indoor management cannot be brought into the picture, because the company cannot be made liable or cannot be held liable for the forgery or for any kind of unlawful activities of the employees. If we look at the case of Reuben versus Great Fingal Consolidated Limited, Reuben was issued certificates by the secretary of the company by forging the signature of the directors and the company secretary of the company. The contract, when Reuben went to court, the court clearly told that the contract is invalid. The company cannot be made liable for the forged activity of one of the employees. Only the particular person who has done it can be made liable for it, not the company. And it is here again the doctrine of indoor management cannot be brought into the picture. The last one what we have is the negligence. There are certain activities, just by looking at it, people will know like something is off about it, right? So due diligence is really important. By looking at it, people will know like it is abnormal. When such a thing is there, no one can claim the benefits of doctrine of indoor management. This can be understood by looking at the case between Anand Behari Lal versus Dinshaw and Co. If you look at it, here the accountant of the defendant company, that is Dinshaw and Co., he had transferred some of the properties of Dinshaw and Co. to Anand Behari Lal. So when the contract between the accountant and the Anand Behari Lal, or whatever transfer that had happened, that became invalid for the reason that Anand Behari Lal should have thought that how an accountant of a company would be given the right to transfer the property of the company. One thing, yes, he should have applied due diligence here, and he should have checked, he should have at least looked for the power of attorney document, checking that whether the accountant had been given the power to transfer the property of the company to Anand Behari Lal, which he failed to do. So the contract, whatever transaction that had happened between the accountant and Anand Behari Lal was considered to be invalid. This was considered to be an act of negligence. So again, the doctrine of indoor management cannot be applied here. Thanks for listening.